Welcome back to the Bald Guys of Bankruptcy. It's been a while. I'm excited to be here with my co-host Adam Friedman to discuss today's topic. Taylor Chip LLC, they're located in Pennsylvania.
This company, they're making cookies? Is that what they're making?
Chocolate chip cookies, essentially.
And they do this near Hershey, Pennsylvania?
Yeah. What does it make you think of, right? The Hershey Chocolate Company. Right. And what's interesting is Hershey is a creditor in the case because they were a supplier of Taylor Chip LLC. They provided chocolate chips. Their claim is about $15,000. So they were founded by a husband and wife. And they had this ritual on date night where they would make chocolate chip cookies. And from that, they expanded. They opened a farm stand locally and started selling. And they became pretty popular. They were a very small company, self-funded. They had no investors. Their focus actually was, and it's interesting, it's these high-quality, non-genetically engineered or modified ingredients. So
how long ago was it?
They opened their first cookie stand actually in August of 2018. And they really rose to popularity through social media. So primarily Facebook. Mm-hmm. At their peak, they had 150,000 followers on Facebook. So they really, from there, developed a robust online cookie business, e-commerce, direct-to-consumer. They were selling it. You can order it from your house, get the cookies mailed right to you. It was a success. From there, they went on to open a few brick-and-mortar stores in Hershey, central Pennsylvania mostly. They expanded to ice cream later on, like 2024.
Sure.
Right? They expanded to ice cream. So, it sounds like a great place.
Well, I gather something went wrong.
Yeah, they did hit some issues. Not before they experienced some rapid growth. They had in 2020 $800,000 in sales. The following year, they saw 350% growth, 2021. Now, what was going on in 2020 and 2021? COVID, exactly. So that COVID boom was really good for businesses like this. I call it a COVID boom. It sounds positive. Obviously, COVID wasn't positive, but some companies did benefit from it, including Taylor Chips, and they expanded on their viral marketing. But they had success. So where did they go wrong, to answer your question? Mm-hmm. Primarily, it started when they attempted to expand. So they tried to open a store in Philadelphia. Okay? They thought the store would open as quickly as it did in central Pennsylvania. They got the permits quickly. They opened the store. They started making profits. Philadelphia, things don't move as quickly. It's a big city. As you can imagine, to get the permits, it actually took twice as long to get the permits than what they experienced in Hershey. So they had this store. They had a lease. They were paying for it, right? But they couldn't operate. So they weren't making any money. So they started losing money right there. Mm-hmm. And even once the Philly store opened, it wasn't profitable. The increased competition in the city, and they saw increased operating costs. The big thing, and we've seen this before in past cases that we've discussed, they got hacked. Their Facebook account was hacked. They lost 150,000 followers. They lost millions of views. They are primarily a direct-to-consumer company, and they couldn't get to the consumers. Mm-hmm. So they lost all these people. They lost access that they were depending on to turn their profit. So that's devastating for a company like that.
Sure.
So they do. So they were struggling. They sought out a small business loan. They actually took out a few through New Tech Bank, approximately $2.2 million they took out just 9 months prior to when they eventually had to file bankruptcy. So even with this influx of money that came in, they couldn't turn a profit and they had to turn to bankruptcy. And they filed just recently. They filed in February of this year.
All those SBA loans, do they have any protections like a student loan would? Like can they be wiped out completely?
Well, so it's a great question. New Tech, in this case, they got secured liens on all the debtors' property.
Okay.
So they were secured. Okay, so they were very protected in this case. They filed bankruptcy. They had about $2.5 million in liability and only $400,000 in assets. So they were extremely insolvent at the time they filed. They immediately closed the Philadelphia store. Couldn't run it. Their plan was to just focus on their e-commerce and their stores located in central Pennsylvania. Essentially, go back to the beginning where they were successful early on. They actually never got around to filing a plan in this case. So when the case started, they filed a couple of expedited motions. The first one was to pay pre-petition wages and ongoing salary, right? So, they filed bankruptcy. They can't just operate their business without court order, but they can't operate a business if they can't pay their employees. So they had to get an order from the court allowing them to do that, which they got. They also filed a motion for use of their cash collateral.
Did the hacking incident, is that resolved now? They now have control of everything?
It's resolved, but they haven't been able to rebuild to where they were prior. So they filed these motions. They proposed a budget for their equipment leases, all operational costs, and payroll, and to pay their creditors adequate protection. So you have to pay your creditors adequate protection as the case is going on through plan confirmation.
Are they looking to wipe out loans that they have?
It's unclear from the docket because they haven't gotten to that point yet. No plan was filed. Likely, yes, unsecured creditors that would get, 0 to 10% of what's owed. Secured creditors have to be paid in full. But yeah, some people would get wiped out.
So when we think about the loans, the SBA loans, we're assuming those loans, well, I know you said they're secured, but their security is probably not enough to cover those loans at this point.
Probably not. If we look at what was intended in their motion for cash collateral, they were going to pay $2,000 a month. That was their intention, inadequate protection payments. So what happened was we saw an objection to that motion by Newtek. Mm-hmm. They said, hold on, they owed us back payment of $26,000 or in arrears because they missed a month. And actually, according to the loan, they're supposed to pay $28,000 a month. So Newtek objected and said, well, we're not adequately protected. You owe us $28,000 a month. You're only providing for $2,000 a month. Your brand was destroyed by this hack. You have no structure for how you're going to rebuild that to show that, hey, you can now eventually go back to where you were. So they opposed it. And the court essentially approved it. There was an interim order to pay. Interim order is temporary, but the court wasn't going to go for that.
When the court's evaluating that, are they more focused on whether $2,000 is reasonable at this point in time, or whether they believe the company can get back on its feet? Because from Newtek's perspective, you want to get paid every month, but even more importantly, you're willing to delay the final resolution because the company can get moving again.
Right, and normally there's a negotiation process. Usually the parties are a little closer, especially in cases that are going to be successful. So perhaps, let's just say, for example, Taylor Chip said, we can pay you $18,000 a month, $15,000 a month. Newtek might have said, okay, let's see. Let's go for a few months. We'll have these interim orders. We'll evaluate it in a few months. And then we'll either oppose ongoing use of cash collateral if we think we need to, or we'll let it go. This case, the parties are so far apart. It's ridiculous. So the court would say, well, not only is that unreasonable, based on where you are, in terms of your liabilities, your assets, you're not making any sales, or at least not to the extent that you were, you don't really have the capability of coming close.
Because I imagine even if you were close, Newtek could say, this is ridiculous, like you're going out.
They could. If it was close, I would say the court would give the debtor a little bit of time.
Okay, so now we're basically monitoring what's going on with the bankruptcy is important procedurally, but I guess there's also the big underlying thing here is how does the business perform? Well,
so Taylor Chip saw the writing on the wall. Okay, and a couple of weeks ago, they filed a motion to dismiss or convert the case to Chapter 7. So it's the debtor's right to dismiss or convert. They filed that motion. The hearing is actually this week, so by the time we air, it'll likely be decided. So they basically have decided we can't operate our business. We can't pay back our secured creditors. We need to dismiss this case or convert to a 7. I don't think it's going to be converted. Newtek has secured liens on all their property. There's not going to be much for a Chapter 7 trustee, which, if it does convert, a Chapter 7 trustee would be appointed. There's not much for that trustee to liquidate. I'm expecting the case to just dismiss outright.
Okay, if it dismisses outright versus it goes to a 7, what would be the difference?
Well, if it dismisses outright, then Newtek goes ahead and they enforce their liens on the property. If it goes to a 7, then all the property is basically under the control of the Chapter 7 trustee. He or she would liquidate what he can, since most of the property is secured by Newtek. Newtek has a secure lien on them. Trustee can't touch those. I mean, he could, but he would have to pay Newtek in full. So there's not going to be any profit for the estate, so it wouldn't be worth it. That's why I don't expect it to convert to a 7. I think it'll dismiss outright. Newtek will enforce its liens. Taylor Chip will no longer exist. I wanted to bring some cookies. I went to their website to order some cookies, but they just shut it down, so I couldn't have anything for today. I would have enjoyed a chocolate chip cookie with you.
I understand the Taylor Chip story. I think it makes sense.
All right. Well, I guess that wraps it up for this edition of Bald Guys of Bankruptcy. We'll see you next time.
Bald Guys of Bankruptcy. Bald Guys of Bankruptcy.